Well, in the last discussion, we have seen the historical background of International Bill of Rights, in which we have also seen how international organizations like League of Nations started evolving for the adoption of International Bill of Rights. Because of certain reasons, because of certain factors, the League of Nations came to its end of its era. Then United Nations came into existence. And we also seen that in International Charter, UN Charter, we find a number of provisions which talks about human rights and fundamental freedoms. Now what we have seen is from concept to theory to well crystallized international human rights law within the framework of international law and rules. Today we shall be discussing on adoption of International Bill of Rights. To begin with, the Charter of United Nations has at least 7 references of human rights and fundamental freedom without defining or enumerating them. It was an inevitable obligation on the part of United Nations and its organs to strive for the formation of International Bill of Human Rights. This was also an arduous work of United Nations to adopt the Global Bill of Rights. However, the actual process of preparing the said bill was begun from 1946 onward, with the establishment of the Commission on Human Rights by the Economic and Social Council in pursuance of Article 68 of United Nations Charter. As a result of continuous efforts made by the United Nations and its organs, a major step in drafting the Global Bill of Rights was realized on 10 December 1948, when the General Assembly adopted the Universal Declaration of Human Rights. Further, with the adoption of 2 international covenants and 2 optional protocols on human rights by the United Nations General Assembly, the whole community has not only realized the task for formation of a global hallmark on human rights, but also endorses the United Nations measures for their implementation and enforcement. So therefore, what we need to say is what kind of mandate on human rights is with the United Nations organization. The main task for drawing up the Global Bill of Rights, including the task of defining the term human rights and fundamental freedom as referred to the provisions of United Nations Charter, was primarily charged with the United Nations and its agency. However, this was not an easy matter for the United Nations to formulate the International Bill of Human Rights within a short period of time, because of the heterogeneous characters of United Nations. To begin with, a proposed draft Declaration of Fundamental Human Rights and Freedom was initially submitted by the representative of Panama in the first session of United Nations General Assembly held in 1946 in London. Thereafter, the General Assembly referred the proposed draft declaration to its committee for their views and commented. Accordingly, the said committee jointly submitted their reports to the General Assembly, and further, the same draft along with the views of the committee was transmitted to the Economic and Social Council, in short ECOSOC. for reference to the Commission on Human Rights. Apparently, one of the main tasks for the Commission, which was set up in 1946 by the Economic Social Council in accordance with Article 68 of UN Charter, was to draft the International Bill of Rights. Such mandate of United Nations, which was extended to the Commission on Human Rights, was also deeply inspired by the global desire to create a comprehensive system for promotion and protection of human rights for all people and all nations. The Economic Social Council further directed the Commission on Human Rights to submit its proposal, recommendations and reports pertaining to a draft of International Bill of Rights. It also requested the Commission to study and explore its views and suggestions regarding the ways and means for effective implementation of human rights and fundamental freedoms. The most important functions of the Commission was primarily to study and prepare a draft on an International Bill of Human Rights. As a part of its obligation, the Commission discussed about the content of such bill in its first sessions. However, concrete steps could not be made for drafting such bill. So in this regard, what we need to see is the specific role being played by the UN Human Rights Commission and its subsidiary bodies pertaining to adoption of International Bill of Rights. The Commission on Human Rights constituted a committee to prepare a preliminary draft of an International Bill of Rights with the assistance of United Nations Secretariat. But such constitution of the drafting committee was criticized by the Economic and Social Council on the ground of disproportionate geographical representation of members of the said committee. Subsequently, with the approval of the Economic and Social Council, the procedure for appointment of the member of the drafting committee was further modified, and a new drafting committee was accordingly constituted, comprising of 8 members of the commissions, with due consideration of the principles of proportionality and respect of the representation of the members. The new drafting committee was assigned to prepare a preliminary draft of the bill on the line of the draft model provided by the United Nations Secretariat. However, there were 2 views in these deliberations. First one view favored for adoption of a Declaration of Human Rights without having binding forces. And number 2, the other view contended that the declaration should be accompanied with a binding document in order to make such declarations as a legally binding international instrument on human rights. As a result, the drafting committee came out with 2 sets of draft documents. That is, number 1, adopt declarations dealing with general principles of human rights, and number 2, draft articles in the form of the binding conventions dealing with meaning of fundamental human rights and the freedom of individuals along with their limitations. Apart from such a set of drafts, the drafting committee also studied and examined the basic issues relating to implementations and enforcement of those contained of the draft. The findings and the views of the committee were also submitted to the Commission on Human Rights. On the basis of the reports submitted by the drafting committee, the Commission on Human Rights prepared a memorandum specially on the question of implementation and enforcement of those provisions of the draft. Eventually, the Commission again constituted a 3 working group to study the draft document submitted by the drafting committee. That is, number 1, the working group on declarations, number 2, the working group on covenant, and number 3, the working group on implementation and enforcement. The working group also considered the views, comments, suggestions, and observations made by the national government, intergovernmental agencies, and non-governmental organizations working in different relevant fields. After taking into account such views and comments, the working group revised the draft declarations and the covenant, and the same was transmitted to the Commission on Human Rights. However, due to the paucity of time, the Commission could only prepare the draft declarations, but not the covenant and implementation matter. The Commission thereafter submitted the final draft to the Economic Social Council for its deliberations. And the same draft was also transmitted to the United Nations General Assembly by the ECOSOC. Now let us see how United Nations, particularly United Nations General Assembly, started evolving the formation of International Bill of Rights. Next, let us see how international organizations took the responsibility for adoption of International Bill of Rights, particularly United Nations General Assembly started working on this seriously. Adoption of Universal Declaration of Human Rights. After having thorough discussions on the content of the draft declarations prepared by the commissions and its subsidiary bodies, the General Assembly adopted the Universal Declaration of Human Rights on 10 December 1948 by a vote of 48-0 with 8 abstentions in Paris at the newly built Place de Chaillot. The declaration became a basic international pronouncement of inalienable, unavoidable right and freedom of all the members of the world community. It has also remained as the first pathfinding international document on human rights. Therefore, the declaration has been undoubtedly termed as the common standard and norms of human rights for all people and all nations. The Declaration of Human Rights consists of a preamble and 30 articles which set forth both the civil and the political right as well as the economic, social, cultural right of individuals. Although the declaration does not have the binding force of law under the international rules, it has undoubtedly acquired universal acceptability in all respects. It is also worth mentioning that the adoption of the declaration without having a single dissenting view of any member of international community and the repeated affirmation of it by the UN General Assembly as well as by the World Conferences on Human Rights held in 1968 and 1993 in Tehran and Vienna respectively, have proved the content of declarations as a part of the international customary law and jus cogens. Besides, there is no such polemic for the world community in accepting the moral value and forces with the high persuasive character of the declarations. For the simple reason is that it has been universally accepted as the main source of inspiration for all. On the other hand, it has widely inspired and influenced the adoption of a number of international documents on human rights, that is, declarations, conventions, covenants, adopted under the auspices of the United Nations and other UN specialized agencies. Similarly, the provisions of the declarations have been well reflected in the various regional conventions on human rights and also in several other national constitutions and domestic laws of the country. So what we have to say in this regard is, having a document without binding character, we need to have some sort of binding international human rights documents. So therefore, the issue of adoption of binding international human rights document was a question before the international organization. The adoption of two sisters covenants. Indeed, the adoption of the Universal Declaration of Human Rights in 1948 was not the end of the United Nations. The global legal system incorporates the human rights provisions as one of the most important provisions to be realized by the United Nations. There are also some guiding provisions set forth in the Charter for the United Nations and its organs to formulate such precise international binding document on human rights, which could also be enforced and implemented by the competent global mechanisms. As a matter of fact, the United Nations Commission on Human Rights was the main UN organ having the mandate to study and prepare the proposal, recommendations, and the relevant reports pertaining to the adoptions of International Bill of Rights. Therefore, it began to study and examine the proposed draft covenant on civil and political rights and freedom of individuals in its fifth session held in 1949. The Commission also sought the views, suggestions, and comments from various national government, intergovernmental organizations, and non-governmental organizations about the said draft covenant. On the basis of the reports submitted through the Economic and Social Council by the Commissions, the United Nations General Assembly made a declaration in its resolution taken on 4 December 1951 that the enjoyment of civil and political rights and of economic, social and cultural rights of individuals is interconnected and interdependent. Henceforth, the Commission on Human Rights prepared a model draft on economic, social and cultural rights in its 7th session held in 1951, especially by relying on the basis of views, suggestions and observations made by the national government and non-governmental organizations. Further, the General Assembly directed the Commission on Human Rights in 1952 to prepare two separate drafts. That is, number one, the covenant containing civil and political rights and freedom of individuals. Covenant comprising of economic, social, and cultural rights and freedom of individuals. So thereafter, the Commission began to work for preparation of the said two international covenant and completed its preparations of the two sister covenant in 1954. And the same was submitted to the United Nations General Assembly through the Economic and Social Council. Finally, the General Assembly adopted the three important international human rights documents in 1960. That is, number one, International Covenant on Economic, Social and Cultural Rights. Number two, the International Covenant on Civil and Political Rights. Third, the first optional protocol to International Covenant on Civil and Political Rights, 1966, which provides the enforcement mechanism along with the procedures for effective implementation of those provisions of the Covenant on Civil and Political. In addition to those three international human rights documents, the second optional protocol to International Covenant on Civil and Political Rights, aiming at the abolition of the death penalty, was also adopted by the United Nations General Assembly on 15 December 1989. The provisions of the second optional protocol applied to the enforcement of the provisions of the Civil and the Political Rights Covenant. Hence, it is quite pertinent to mention that such a universally accepted norms of human rights has been precisely laid down in the multilateral international treaties adopted within the framework of United Nations Charter. After having gone through the various events where international human rights documents have been adopted by the United Nations General Assembly, now we come to the conclusion. It is apparent that the Universal Declaration of Human Rights of 1948 was the first of its kind and also a first part of International Bill of Rights. Another part of the said bill, which was designed to elaborate the content of declarations, took many years to be completed. However, the adoption of those instruments of Bill of Rights revealed that the international community not only agreed on the content of the provisions set forth in the declaration, but also accepted the measures adopted for their implementation and enforcement. The International Bill of Rights gives a comprehensive global legislation on human rights, consisting of both the set of rights, number one, civil and political rights, number two, economic, social and cultural rights. It has undoubtedly become an international benchmark for human rights to be achieved and realized by all the people and all the nations. It consists of 5 major international multilateral human rights treaties. The first document, the Universal Declaration of Human Rights, 1948, in short, UDHR. Number 2, the International Covenant on Civil and Political Rights, 1966, in short, ICCPR. Number 3, the International Covenant on Economics, social and cultural right, 1966, in short, ICESCR. Number 4, the first optional protocol to ICCPR. Number 5, the second optional protocol to ICCPR. With the adoptions of the 2 sister covenants and 2 optional protocols to the ICCPR, the United Nations intended to bring the rights and freedom outlined in the Universal Declaration of Human Rights into the enforceable realm of international law and rules. Such initiative undertaken by the United Nations on the human rights front have also virtually endorsed the United Nations General Assembly resolution of 1950, in which it was declared that the enjoyment of civil and political rights and enjoyment of economic, social, and cultural rights are interconnected and interdependent. Henceforth, the United Nations has also fulfilled one of its cherished goals enshrined in the United Nations Charter. One of the glaring examples is that the United Nations Charter, together with the International Bill of Rights, could serve as an inspiration and also a means for millions of people who were under the colonial rule to achieve right to self-determination within the legitimate ambit of global system and rules. With this, thank you very much.